Hello and welcome to another free talk by LawWorks. That's part of the service that we provide to small not-for-profit organisations through the Not-for-Profits programme. This is the second one recorded during lockdown, hence the interesting format. I'm Matt Hunt, Head of Not-for-Profits and Secondary Specialisation, and today, because we're talking about charity property transactions, I'm very pleased to be joined by Tim Wrigley, who's a partner in the Charities and Social Economy Team at Wrigleys Solicitors, to discuss some of the things charities and their advisors need to be aware of. So, Tim, thank you very much for joining us. When we talk about charity property transactions, what makes them different from other transactions? And should charity trustees and their advisors be concerned about property transactions?
Well, where charities are involved, as well as getting property law right, you also have a whole extra regime of charity law and charity trustees' duty to consider as well. To set the scene, I should say, I'm going to talk about the system in England and Wales, and it is different in other jurisdictions. And even the systems in England and Wales are diverging more and more with different property tax regimes, for example. Obviously, properties are relatively high value and therefore comes with a higher risk than most other assets, and you need to bear that in mind. Perhaps there's a bit of a tendency for some people to think that property can be relatively straightforward, and some people might be tempted to try and do it themselves. After all, the majority of law firms have a property department of some sort or another, and most of us will own or rent a house or a flat. So most of us have some experience of property transactions in some form or another. There is also, in my view, an increasing public perception or demand that property transactions in general should be quicker and cheaper, and therefore perhaps that it is an easy subject. But in my view, charity property transactions are not suitable for doing it yourself. This is a specialist subject, and there are various traps that you could fall into. Property solicitors and conveyancers who aren't experienced with charities should also consider a transaction carefully before taking them on. Perhaps the biggest problem is the system of registered land, and that only deals with the legal title. So if you look at the land registry legal title, it tells you who owns and who holds the legal title, but it doesn't cover any trusts, and it doesn't cover the beneficial interest in the property. So there are many charity concepts which aren't revealed by the title registers held at the land registry. That's not the land registry's fault, that's how the system of registered land was designed and how it operates. Charity trustees don't need to be scared about getting involved in charity property transactions, but they do need to understand that it is high value and it's a technical area. Not every transaction is going to be complicated or have any problems, but in my view, the risk of getting transactions wrong can be quite high and have a high impact on the charity and indeed the unwitting lawyer who makes a mistake because they're not familiar with charity law.
Okay, understood. So high value, high technical, potential high risk. Could we start to unpick that? I'm aware there are lots of different types of charities. Are property transactions the same for all types?
You're right to point out there's lots of different types of charities. Their property needs, how they go about entering into transactions, and the laws and regulations around them can be very different. There are big differences, significant differences between incorporated charities and unincorporated charities. And there are several charity sectors which have additional legal regimes and regulations on top of property law and on top of charity law that we've already talked about. For example, education law and housing law, they both have a whole nother raft of provisions on top. And again, these can trap the unwary.
Okay, so before we get into some of the potential issues, you just mentioned that there are significant differences between incorporated charities and unincorporated charities. Could you briefly explain why they're different and what the significance of those?
Yes, of course. A charity isn't a type of legal structure or a legal personality itself. Most charities are structured either as companies, CIOs, charitable incorporated organisations, trusts, or unincorporated associations. Now, of those four, companies and CIOs are incorporated. This means that in law they exist as a separate legal person, and they can own property, they can employ staff, and they do all of those sorts of things in the incorporated charity's own name. On the other hand, trusts and unincorporated associations, clearly they're not incorporated, they don't have a separate legal personality. A trust is constituted by the trustee, an unincorporated association has a set of rules, and those govern how they operate. Usually the trustees or some nominated trustees hold the charity's property and their other assets and employ any staff for the charity, but the charity cannot do it in its own name. It doesn't exist to be able to do anything in its own name. Incorporated structures are generally much more suitable for charities who own land and buildings. There's two main reasons for this. Firstly, because it's easier if the property is held in the charity's name, whereas if the trustees of an unincorporated charity change, then you have to transfer the property and all the other assets every time there's a change of trustee, and that can be administratively burdensome. And secondly, nearly all incorporated charities have limited liability, and that comes with the legal status of the company or the CIO. This means that the members, possibly shareholders if it was a share company, and the directors, who are the charity trustees in the incorporated structure, these individuals are generally not personally liable for the actions and debts of the charity, whereas because they don't have a separate personality and they don't have limited liability, trusts and unincorporated associations, those trustees and the members of the association could be personally liable. So to reduce risks to people running a charity or involved with a charity and to simplify the holding of property, I would usually recommend that an unincorporated charity considers becoming incorporated before buying a property or entering into a property transaction. Or on the other hand, if you're thinking of setting up a brand new charity and you're thinking you will own or use property, then choose an incorporated structure from the outset.
So it's a really good idea to incorporate then.
Yeah, absolutely. As I say, if you're starting up a new charity, it's a no-brainer. If you've got an existing unincorporated charity and want to incorporate, that's a whole topic in itself, really, and there is a separate LawWorks video about that. Depending on the existing arrangements, there may be some effort and legal cost involved in dealing with incorporating that charity. But if you compare that against the cost of having to do a property transfer every time trustees change, i.e. someone comes or goes as a trustee, coupled with the benefit of getting limited liability for the trustees and any members, it's usually worth doing it, in my opinion.
Okay, and so forgive the slightly pertinent question, but the issue seems to relate to which legal personhood is responsible for the charity. Is this really an academic issue, or is it actually a real practical issue that people need to be wary of?
It's very much a real issue. I frequently see legal documents, including lots done by lawyers, where an unincorporated charity is named as a party to a conveyance, a transfer, a lease, and sometimes even on the registered title at the land registry as named as the proprietor. I probably see this a couple of times a month. And as I say, this is simply wrong because an unincorporated charity does not have a legal personality in law. So it cannot have legal effect in that sort of way. And that raises a question about the whole validity of what was done and what the legal effect, what did happen, would be. where this sort of thing happens, it can take an awful lot of time and effort to unpick the mistakes that have been made and to correct them. And it's also a high risk for the people who prepared those documents and the people who signed them. The people who signed them probably don't know it, but those individuals might be personally liable for the property deal and what happens at the property. And they definitely won't have limited liability. They may not even be entitled to have recourse to the charity's assets, and their property insurance is probably invalid as well. This sort of thing can often go unnoticed, and often goes unnoticed for many years. But occasionally some sort of disaster occurs, and that's when people do notice, and it becomes a real genuine issue. For example, if a charity owns a historic house and the house burns down, or perhaps a charity has an activity centre and a child has a serious injury there, you might only realise that this whole issue was a big problem when you put in your insurance claim and you find out that the insurance is invalid. And in those situations, the individuals, as they themselves, could be personally liable. There could be serious risks of claims against themselves, and serious amounts of money could be involved. And of course, if you were the lawyer who dealt with that matter, then there's a real possibility of a negligence claim against you as well.
Right, that makes sense. So we established that the legal status of a charity is not just interesting, but really important. It can make a big difference. What else do we need to know about this topic?
Well, there are a lot of things, but let's talk about some of the basic principles that charities exist for particular charitable purposes. So a charity's purposes, which are also known as objects, will be specified in the charity's constitution. And the constitution will either be articles of its company or a trust deed or rules of an association. And there are lots of different types, and you can't assume that a particular charity can do a particular thing or a particular property transaction without checking the constitution, without checking the objects. For example, a charity whose purpose is to provide housing to the homeless cannot carry out a totally different charitable activity, such as education. Or the charity local to me in the Leeds area, who exist to help educate children in a specific area of Leeds, who recently asked me to help them establish a project in Africa, they can't do that either because their area of benefit is limited to Leeds. The charity world is not quite as straightforward as those couple of examples, but the point here is that charities and their advisors always need to check the purposes before embarking on any project and getting involved in any property transaction. If a charity gets into a transaction that it doesn't have power to do, there's a risk that the transaction could be invalid. And again, I'm afraid there's risk of personal liability for the people who did it and the trustees of the charity. Shall we also talk about the concept of best value?
Yes, please, let's do that. So I think I know this one. Does it mean essentially that charities must get the best value when they sell properties?
Yes, in general, that's right. But we need to remember it's not just selling property, but also granting leases of property and all sorts of other property transactions too. There are, of course, some exceptions to the general rules, there always are. But if you set out with a mindset that a charity must obtain best value, then hopefully you won't go too far wrong. The principle about getting best value is enshrined in Part 7 of the Charities Act 2011. And that stems from and is underpinned by general trustee duties, which at its most simple means trustees have to act in the best interests of the charity. Section 117 of the Charities Act 2011 contains a general prohibition on charities disposing of land, including buildings, unless the charity obtains a consent from the Charity Commission, or you can go through a procedure to ensure that they obtain the best possible terms for the charity, unless an exemption of some sort applies. Interestingly, the Act doesn't actually say that the charity has to get best value. It says the trustees have to get the best terms. Of course, hopefully it's obvious, price is a really big, very big and important part of that. But it's oversimplifying the technical legal position if you just assume the highest price obtainable is the best terms. But generally speaking, again, you're not going to go too far wrong if you take that approach. Sometimes when selling land, charities do end up getting a higher offer from one person, but for some reason or other, they might rather sell to a lower price to a different person. And sometimes this can be justified depending on the circumstances, but it's another one of those areas where you're really going to need some specialist advice before you go down that route or even consider going down that route. In practice, the policy position of the Charity Commission means that if you can use the self-certification route where you obtain best value, then you should do that. If you do need to ask the Charity Commission for a consent to a transaction for some reason, then the first thing the Charity Commission will ask are some questions to check that best value is being obtained, or if not, what is the good reason for why best value isn't being obtained. The self-certification route involves getting a QSR, a Qualified Surveyor's Report, under the terms of the Charities Act, and that advises on how the charity must market the property in order to obtain best value. To give you a quick run through of a very simple transaction, in summary, the process is, first of all, the charity trustees decide that they might want to sell or grant a lease or some other sort of property transaction. They then have to go and obtain a QSR, Qualified Surveyor's Report from a surveyor, advising on the sale, advertising, and the trustees have to obtain that report and review it. They then advertise the property. Hopefully they get some offers from some interested buyers or tenants, and then the trustees review the offer in view of the report's advice and valuation, and make a decision from there. As I say, there are a couple of exceptions, but this is getting into even more specialist and technical detail. I'll just quickly mention a couple of the most common ones. So first of all, a charity doesn't need to get best value if the transaction, the property transaction, is with a beneficiary of the charity. To give you an example of this type of transaction, housing charities provide an obvious example. Housing charities help their beneficiaries by giving them free or low cost accommodation. And clearly they couldn't do that, they couldn't operate at all if they had to get the best value from their beneficiaries who need the housing. And the second point, a charity doesn't need to get best value if they are selling or leasing to a different charity, but for their charitable objects, for their purposes. For example, if Charity A exists to provide housing, then it can sell or transfer property to Charity B to carry out housing at whatever value they like, or even no value at all. There are still traps here. So again, be wary about it. And the most common one is a misconception that any charity can transfer to any other charity, but that's not right. Charity A, our housing charity, cannot sell or sell for free or under best value to, say, Charity C if Charity C looks after animals rather than provides housing.
Yeah, that makes sense. Thank you very much. It seems relatively straightforward principle that charities should get the best value, or the best price. What happens if they don't? Or really, what I suppose I'm asking is, do charities and their advisors get this wrong?
Yes, again, I'm afraid people do get it wrong. Charities don't often end up in court battles, and there aren't that many well-known legal cases involving charities, but there are a few. And the one that all the charity specialists know is called BOME, BOME against the Women's Total Abstinence Educational Union Limited, back in 2004, where, as I say, there's not that many that come through. And the decision in this case basically said that if you don't get the Charities Act Section 117 process right, then a contract to sell the property can be invalid. And actually, in that case, it turned out that was for the best for the particular charity who had got themselves involved in a deal which really wasn't in the best interest of the charity. They hadn't gone through the process properly, and they were able, in that instance, to get out of the transaction. But you don't want to be in that charity's shoes in the High Court, and you don't want to be the lawyer who dealt with that, who'll be worrying about negligence claims, and of course having a dubious record of having created an invalid contract. There's another more recent, well-known example. I say more recent, it's still a few years ago now, and that involved a charity called the Spiritualist Association of Great Britain. Again, they didn't follow all the charity law processes properly about when to get the report and the valuation advice and how to go about it. They sold a property for £6 million. And that sounds like a lot, but very shortly afterwards, the buyer sold it on again for £21 million. And the Charity Commission opened a formal statutory inquiry into the charity and found that the charity trustees had effectively caused this loss of £15 million to the charity by selling the property too cheaply by not following the processes properly. And this was basically serious mismanagement of the charity. So yes, there is a real risk that a transaction can be invalid if you get it wrong. I should say that the Charities Act doesn't set out specific penalties if charity trustees get the process wrong, but general trust law principles and fiduciary law principles apply. So charity trustees could be potentially liable for causing loss to their charity in really serious cases.
Yes, I'm sure any charity trustees watching this want to avoid a £15 million risk. So that's selling properties. What about the other side? What about buying properties?
Yeah, good question. As we've said, there's a specific regime set out in the Charities Act when it comes to selling, but that doesn't apply to buying. There isn't an equivalent. I think Parliament, who write our laws, think that there's a bigger risk to charities when they're selling property. Perhaps they think there's a bigger risk of selling too cheaply than there is of buying a property too expensively. However, that doesn't mean that charities and their trustees can simply do whatever they like. As I said earlier, the specific rules about dispositions, about selling and granting leases, they're based on the general trustee's duties to act in the best interests of the charity. And clearly, in the same way as selling a property too cheaply isn't in the interest of the charities, it's not going to be in the best interest of the charity either if you were to pay too much for a property. So no specific regime, but to discharge their duties properly when it comes to buying a property or taking a lease of a property, similar sorts of principles do apply. Charities should still get valuation advice or advice from a surveyor or a property agent on the terms of the transaction or lease that they want to enter into. They should also conduct appropriate due diligence on the property, i.e. investigating the property, finding out what liabilities might attach to it. That might seem obvious if you're paying for a property, whether that's for a functional use of your charity. For example, if you're an animal charity, you might need some space for the animals, or it might be for office space. either because you provide advice and you need meeting rooms, or perhaps you just need some back office function space for the charity. But you want to know that the charity has, the property you're interested in has all the necessary rights you need, and you would want to know that there aren't any hidden liabilities. And as I say, that hopefully that's obvious when you're buying property, particularly, or when you're paying for a lease. But perhaps it's not as obvious when you get a gift of a property from a donor or through a will. In those sorts of circumstances, and again, we do see this in reality, it almost seems that there's a temptation to assume that being given a property is obviously a big benefit to the charity. And quite often that's going to be the case, but it is still worth checking the terms of the gift and doing due diligence on the property. There have been a couple of examples where a property turns out to be a lot more trouble than it's worth, really. And there's a few examples, a few reasons why that could be the case. It could be contaminated land, might be a listed building in need of some serious repairs, and the charity might struggle to afford to do those sorts of things. So, as I say, getting a gift of a property or being informed of a legacy in the will sounds great, but do just think about it a little bit before signing on the dotted line. As with selling, the Charities Act doesn't set out any specific penalties if charity trustees get a process of buying or acquiring a property wrong. But again, the general principles in trust law and fiduciary laws apply. So again, if there is a serious case where charity trustees got it wrong, then again, they could potentially be held liable for causing loss to the charity.
Okay, well, brilliant. This has been really helpful, Tim. Thank you for taking us so well through the sort of principles, process, and risks of selling and buying property as a charity. Before we finish, could I just ask you what are the key points for charities and advisors on their topic?
Yeah, absolutely. The first one, and the one I really need to stress more than anything else, is that you simply cannot only look at the property deeds or the land registry title. And this is vital for property lawyers who include myself in this. We sometimes get a bit of tunnel vision towards what we see on a land registry title. But with charities, you really must look at the charity's constitution, and you have to look at all the surrounding circumstances of the transaction much more generally. As I say, you really have to know that the charity has the legal power to do what it wants to do. Secondly, you should normally get an agent or surveyor's advice on the terms of the transaction, whether that's because the Charity Act says you have to do, or because that's the sensible thing to do as part of discharging your duties as charity trustees. And it's important that that should be done at the outset of the transaction. Getting that report shouldn't be done at the end to sort of sign off a deal that you've already agreed. It's really important that you do that at the outset. Thirdly, I would say using a specialist, experienced charity property lawyer is the safest approach. Not every transaction is going to be hugely complicated or have hidden trap, but some of them do, and some people will get caught out. And then finally, read the Charity Commission guidance in publications and read the Land Registry Practice Guide. These are good resources with good amounts of basic information that will cover the majority of transactions. So there is help out there, and I encourage you to use it.
Brilliant. Well, thank you again, Tim, for joining us. I'm not sure whether this will show on the recording, but for doing so with such dramatic lighting, brilliant. But yes, also thank you for thank you for so clearly talking on and guiding us through the main issues and risks of an important issue. I'm sure people have found this extremely useful and interesting. I'd also like just to thank my colleague, Devjini Biswas-Hawkes, who put in much of the preparatory work for this free talk and was keeping Tim and me on course by steering us through the slides. So thank you also to Devjini. And that's the end of this free talk. Thank you for listening.